Many employers in Vietnam include non-compete clauses in their employment contracts, with the expectation that they will prevent employees from joining competitors. But when an employee resigns and immediately moves to a competing company, the question quickly arises, can employees legally ignore non-compete agreements in Vietnam? The answer is not as straightforward as many foreign investors expect. A non-compete agreement is designed to restrict an employee from working for competitors or starting a competing business. After leaving the company, from a business perspective, this is understandable. Companies invest time, resources, and proprietary knowledge into their employees. They want to protect trade secrets, client relationships, and internal processes from being used against them. However, in Vietnam, these objectives must be balanced against the employee's legal right to work. Vietnam labor law places strong emphasis on protecting employees' rights, including the freedom to choose employment. Unlike some jurisdictions, non-compete agreements are not explicitly regulated in a comprehensive way under Vietnamese law. This creates a legal gray area. While confidentiality obligations are generally recognized, post-employment restrictions, such as non-compete clauses, must meet strict conditions to be considered enforceable. If these conditions are not met, the clause may be ineffective in practice. In many cases, non-compete agreements in Vietnam fail because they are drafted too broadly. For example, clauses that prohibit an employee from working in the entire industry, across all locations, for an extended period of time, may be considered unreasonable. If a restriction significantly limits an employee's ability to earn a living, it may be challenged. As a result, even if the agreement is signed, enforcement becomes difficult. In practice, some employees do ignore non-compete agreements. They leave a company and join a competitor, assuming that the employer will not be able to enforce the restriction, and in some cases, they are correct. If the non-compete clause is not properly structured, or if it conflicts with labor law principles, the employer may struggle to take legal action or obtain meaningful remedies. This does not mean non-compete agreements are useless. It means they must be carefully designed. To increase enforceability in Vietnam, non-compete agreements must be reasonable in scope, duration, and geography. They should clearly define what constitutes a competing business, and what activities are restricted. In certain cases, providing compensation to employees during the non-compete period can strengthen the legal position. Most importantly, the restriction must be tied to legitimate business interests, such as protecting trade secrets or confidential information. Without this connection, the clause may be viewed as excessive. In Vietnam, confidentiality obligations are often more enforceable than non-compete clauses. Instead of relying solely on non-compete agreements, companies should combine them with strong non-disclosure agreements and internal controls. Protecting specific information can sometimes be more effective than trying to restrict employment entirely. This approach aligns more closely with how Vietnamese law evaluates contractual obligations. Even with a well-drafted agreement, enforcement is not automatic. Employers must be able to demonstrate that a breach has occurred, and that it has caused actual damage. This requires evidence, such as misuse of confidential information, or direct competition using proprietary knowledge. Without clear evidence, enforcement becomes difficult. This is why legal drafting must be combined with practical risk management. For foreign investors, misunderstanding non-compete agreements in Vietnam can create serious risks. You may believe your workforce and business secrets are protected, when in reality, your legal position is weak. This gap can lead to loss of competitive advantage, especially in fast-growing and competitive industries. Understanding how Vietnamese law treats these agreements is essential for protecting your investment. At LTS Law, we advise foreign investors and companies in Vietnam on how to structure enforceable employment protections. This includes drafting non-compete and non-disclosure agreements that are aligned with local legal requirements and practical realities. We also help design broader legal strategies to protect business interests beyond contractual clauses alone. Our focus is to ensure that your agreements work not only on paper, but in practice. Non-compete agreements in Vietnam are not absolute. Employees may challenge them, and in some cases, they may not be enforceable. Before relying on these clauses, it is important to assess whether they are legally sound and practically enforceable. If not, your business may be exposed to risks you did not anticipate. Visit lts.com.vn to consult with our legal team and ensure your employment agreements in Vietnam are structured to protect your interests effectively.